I will speak about processor agreements, and why am I going to do that? Because I think that's the traditional way you as a customer think of your service provider. And so that's the way it was drafted some time ago. I think it was much more the classical outsourcing situation, but not really cloud computing situation. So I'm asking, how do these rules on processor agreements fit to cloud computing? And obviously this is more the B2B cloud computing. I'm not talking about a private consumer like myself using Hotmail or Google Mail or whatever. So I recognize that instead of talking about rules on processor agreements, the title could well be How to Squeeze Cloud Computing into a Traditional Outfit. And I think of it like, we have this fancy cloud and it has to be squeezed in such a traditional Bavarian lederhose. And how does this go? And well, we'll see. I don't think I'm the one to present the solutions here today. We already have talked about jurisdiction and applicable laws. This is really a nightmare if you think about multiple transfers, a processor, a provider, sub-processors somewhere else. And I think you only talked about what is the law applicable to the data controller, but you can also ask what is the law applicable to a processor relationship. I mean, is it the law applicable to the processing at the side of the data controller? Or what's the local law for the data processor? You could go on and on. I want to touch a little bit on the question, who is a controller and a processor? Because I think, at least from a German point of view, we have some more guidance now by the Article 29 working paper. And I think it's quite helpful because in Germany there has been a little bit of a problem when deciding what level of discretion may a service provider have. It was always said everything has to be set by the data controller, and there was not much flexibility, and I think this working paper gives a little bit more of that. It says there's two basic important things. There's the purpose and the means, and the data controller should always determine on the purpose of the data processing and on some issue of the means, like which data are processed, who should have access, for what purpose, and how long should the data be stored. That's clearly up to the decision for the data controller. But on the other hand, when we talk about technical ways how to implement all this, that's at least how I read this paper, there's a little bit more discretion for the service provider. For example, I mean, it's obvious that there must be security, sufficient security, and it's somehow there must be agreement on what it is. But what exactly it is and how you implement this, it hasn't to be the data controller really writing a security manual for Google. He will not be able to do that. So I think this paper is giving a little bit of an idea that there could be some discretion on technical aspects, and I think that's helpful when deciding whether or not you can apply a processor relationship at all. Because, I mean, as you pointed out, having two controllers will raise new questions. I mean, it will not make things easier. Now, that's the first issue. So I think we could maybe live with that and accept that a cloud computing provider will be maybe a data processor. Now, in Germany, we have new rules on data processing in general. First of all, this is applicable to data processor agreements in Germany or within the European Union. And I spare the part where it gets really complicated what it is when the data processor is outside. But basically, the German authorities say, well, it's basically the same. So we have really now in the law, there's a list. There's a list of 10 key elements which should be in each processor agreement. And I think some of them are pretty obvious, and it's fine for cloud computing agreements like subject and duration of the work, extent, type, and purpose of processing. You can nail that down. Technical and organizational measures, that's a little bit more difficult. I mean, it also depends on what level should it be. I'm sure a good provider can give you something to nail down in a contract, but how detailed should it be?